Major breaking news. The United States Court of Appeals for the Ninth Circuit in a 3-judge panel heard oral argument as to whether or not California's quote-unquote assault weapon ban is constitutional under the Second Amendment. The 3-judge panel with 2 liberals on it, not impressive. Let's talk all about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. All right, folks, major argument went on for about 45 minutes or so in the United States Court of Appeals for the Ninth Circuit out in California as to whether or not California's assault weapon ban, propaganda term, but that is exactly what the language of the judges, at least the 2 liberal judges, it was a 2-1 judge, one was a Trump judge, Judge Miller. So anyway, they kept talking about assault weapons, which of course is a propaganda term, because it's pretty clear that the 2 liberal judges have no idea anything about firearms. One of the judges actually made a reference to an A-15. I'm not joking, A-15 as opposed to an AR-15, and a lot of other evidence of not understanding how firearms work, including asking what exactly is a semi-automatic firearm. But nevertheless, let's not get into that in this video. We can cover that in future videos. The big thing is I want to hit like a couple quick highlights, play some of the video so you can see exactly what happened in court, and then we can talk about all of this stuff in future videos in even greater detail. To begin with, I will say that the attorneys for the plaintiffs in support of the Second Amendment did a great job. Specifically, I thought they immediately pointed out the hypocrisy that we've talked about on this channel before involving California's position. Because what they point out was that in the Heller case in 2008, guess what? In that case, the government argued that handguns were bad for self-defense and handguns were generally bad, and that long guns like rifles were good. And the lawyer here did a great job pointing out, hey, seems like the anti-gun movement in America has flipped their position. Roll the tape, check out this argument.
These are firearms that people use for lawful purposes broadly across this country, and they are indeed the most popular rifles in the history of this nation. And so the notion that the most popular rifles in the history of this nation could be deemed dangerous and unusual is just implausible. And the arguments that are being made here are basically the reverse of the arguments that were being made in Heller. In fact, at pages 54 to 55 of DC's brief in Heller, they cited an article from guns.com that said some people prefer long guns for self-defense to handguns. And Justice Breyer cited it as part of the brief in his dissent. And if you look at that guns.com article, what it says is that handguns are not good self-defense weapons, but instead rifles are better. And there's a picture of a semi-automatic rifle with a pistol grip. And that the plaintiffs in DC were saying this was the alternative that people have to defend them. Not the plaintiff, the District of Columbia was saying that this is the alternative that people can have to defend themselves. There was evidence there in the Violence Policy Center put before the Supreme Court to say that these are the preferred, handguns are the preferred weapons for mass shooters. And they're by far the most preferred firearm for criminals to use in this nation. But the Supreme Court rejected all of that. And this case is essentially taking the very same arguments that were made against handguns in Heller and repackaging them to be made against assault weapons. And those arguments did not prevail there, and they can't prevail here. And what's interesting is the opposing counsel mentions mass shootings, which is, of course, are deplorable, awful events. But their expert, Clarivas, had an increasingly gerrymandered definition to try to get to certain shootings where AR-15s are used in those. And he identified 16 shootings from 2012 to 2022, and he said 75% of those involved an assault weapon. And those are tragic incidents, deplorable incidents, but if you add up the number of deaths in those incidents, it's 300 and something. Every single year in this country, 6,000 to 7,000 people are murdered with handguns. So that's every month. More people are murdered with handguns than were in the entire decade of those shootings cited by the opposing side's experts. That's not to say that this is not a problem, but it's just to say if that did not suffice in Heller, similar type of evidence can't possibly suffice here.
Great arguments there. Let's carry on. The next interesting point is the judges pressed the Second Amendment attorney about the features. And what's interesting is the irony here is that if you think about it, California was taking the position that they're allowed to ban particularly dangerous features of semi-automatic firearms that turn those semi-automatic firearms into weapons of war, turn those weapons into offensive weapons and not defensive weapons. But what's ironic, and it's the attorney for the Second Amendment movement made a great argument here, is that indeed, by removing the features, you've actually made those weapons more dangerous, not less. Roll tape right here.
Banning features here that enhance the control of a firearm. So it's actually backwards. The firearms that are left after California's ban are more dangerous because they're harder to shoot accurately.
Now, the next thing that's very amusing is that there was a discussion by a new judge who's a Biden appointee talking about whether or not, how do you figure out what is in common use for law-abiding or by Americans for lawful purposes? So she tried to show that she was an intellectual giant by asking this sort of, how do we measure it? I mean, do we look at whether the weapons are in common use in California, in a particular town, or in the country? How do we do it? Come on, moron. We know the answer. What is the Second Amendment? It's a federal constitutional right, which means you look to America, not to any individual jurisdiction. And let's see what the lawyer for the Second Amendment has to say in response to this question.
You're relying very, very heavily on just the number. So as I understand it, of the 24 plus million assault weapons that are out there, owned by under 8 million people, right, out of the population of 330-something million people. So setting aside the circularity problem, I think if you dig down to the numbers, it creates a problem for you as well, setting aside the circularity. So what numbers are we talking about? Are we relying on national numbers? This is a California statute. Do we then look at only the number of assault weapons in California and focus more on the local jurisdictions, which is something that the Supreme Court acknowledged? There are a lot of problems that are looked at a local level, right? So if you only identify the numbers of assault weapons in California, that's a substantially smaller number. And then do we then carve out assault weapons owned by law enforcement, which are then exempt? I don't even know if it's in the record how many that would be. So can you address those problems with your 24.4 million assault weapons that's out there?
Yes, and we're not relying solely on numbers. So our position is that it's the state's burden to show that these are dangerous and unusual firearms. And as this court said in Teeter, that means it's a state burden to show both that they have uniquely dangerous propensities and that they are not typically possessed by law-abiding citizens for lawful purposes. And so if there are millions of an item, that means that the state is simply not going to be able to show. It's a sufficient but not necessary condition. The state is not going to be able to show that these are not typically possessed by law-abiding citizens or that they're highly unusual in society.
Amazingly, California actually gets hooked up and screws up big time, and I'm not even sure they understood it, because they specifically try to invoke a language from NYSRPA versus Bruin to advance the argument that when modern guns somehow implicate modern societal change or technological change or whatnot, guess what? They get to ban things that were otherwise not bannable under the Second Amendment. This is not true, because it turns out that the lawyer for California doesn't properly cite the relevant legal proposition. Let's roll to the tape, and then I'll show you what should have been said in 1 second.
Rubric under Heller and Bruin means in common use, so if now, not previously. And so one looks at the current situation and simply says, well, there are just so many of them that they're in common use, and that's the end of the story. But that has varied actually over time, depending on whether it was regulated or not, illustrating the circularity. So what would you look to? I mean, how do you decide? You're adding a qualifier, which is it's not in common use, it's in common use for self-defense, and that the fact that many people have them at home is not the answer to the question. So what is the answer to the question? I mean, how do you look at what is, what evidentiary criteria do we use to decide what's in common use for self-defense? Otherwise, I mean, these people apparently have them. What are they doing with them?
So that's for the plaintiffs to present evidence on. The plaintiffs have not shown that these types of weapon configurations are the type of weapon that would be for ordinary self-defense.
Suppose you've got 24 million people to sign a declaration saying, I have it because I think it's good for self-defense. Would that be the answer to the question?
No, the court would still need to look at the character of the weapon. But even assuming that these weapons are presumptively protected. At the historical stage, we have developed a robust record of historical analogs and a tradition of firearm regulation that imposed a comparable burden on the right to armed defense that were comparably justified, especially under a more nuanced approach, which the Supreme Court in Bruin made clear is required when the state is defending a law that addresses a dramatic technological change from the technologies in place in 1791 or 1868.
Well, of course, we know what the problem there is because, as you saw, the lawyer for California, who overall did a pretty good job with a weak case as I see it, but he's got a friendly panel with two liberals that don't like guns. Clearly, if you ever want to experience what it was like in the 1950s, where you had judges in places like Alabama and Mississippi who were trying to look for any excuse possible to not desegregate society down there in public accommodations and schools and the like, well, all you need to do, as I see it, is watch the two liberals on this panel of Miller versus Bonta, and you can see how they're desperately trying to get around binding Supreme Court precedent and with all sorts of intellectually dishonest questions and games pretending to be ignorant. All goofy, all silly, but it's embarrassing that federal judges who swear an oath to uphold the Constitution are clearly trying to avoid doing exactly that. But let's carry on. So California just made that argument you just heard about societal change, but we've talked about it before. No can do. Tell me if this language from NYSRPA versus Bruin points out and demonstrates beyond a doubt that the California argument that if you have technological changes that are unprecedented or societal changes that are unprecedented, you get to make stuff up and ban things and take away a right to keep and bear arms that you would not otherwise be able to do so. Here's what the Supreme Court said in Bruin, specifically, quote, while the historical analogies here and in Heller are relatively simple to draw, other cases, you hear what I just said? Other cases other than Heller and Bruin, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. So here you have a situation where the clearly applicable law in an arms ban case is to apply Heller, and California stands up there and tries to say, oh, we can ignore Heller because of dramatic technological changes as referenced. No, because you see what Bruin specifically says, the Supreme Court says that in cases other than Heller, you may be able to have to be a bit more nuanced with your analogs, but that's not the case here because Heller is the binding law. That was conveniently skipped by the attorney for California. I wonder why. The other shocking argument made by California, which makes no sense and is totally inconsistent with what Heller said, is they try to argue that the U.S. Supreme Court has severed the operative clause, which is the right of the people to keep and bear arms of the Second Amendment, the operative clause, from the prefatory clause, which is a well-regulated militia being necessary for the security of a free state. And they try to say, specifically, you'll see here, that they've been separated by the U.S. Supreme Court, and that's why they get to modify the in common use test to simply commonly used for self-defense. Here's what they have to say, and then you'll see why it's clearly wrong.
The Supreme Court severed the relationship between the prefatory clause, which is focused on militia service, and the operative clause, which is focused on weapons for ordinary self-defense.
Now, of course, this is not true because it actually works in reverse. If you look at the Supreme Court decision in Heller, it says that because Americans were supposed to bring their commonly used, commonly owned firearms and weapons that they used on their farms, that they used in their homes, for normal, ordinary day-to-day life. Those were the common weapons that they were supposed to bring to militia musters. You see, that's the connection between the Second Amendment's prefatory clause and the operative clause, which is that at a minimum, maybe more than this, but at a minimum, if weapons are in common use by Americans for lawful purposes, they're protected because those are the kinds of weapons the Founding Fathers would have expected you to bring to militia musters, which obviously means things like AR-15s, semi-automatic rifles, semi-automatic handguns, shotguns, and so on. Obviously, at a minimum, these are protected. There may be a lot more weapons protected beyond that, but for our purposes right now, AR-15s and magazines that hold more than 10 rounds is where the fight's at, so we have to win that now before we talk about other things. And what's interesting is how California tried to play this game, and specifically I should say that the judges stood up and tried to criticize the Heller in common use test, but they were devastated by virtue of this rebuttal by the Second Amendment lawyer, who points out that really all the questions that the judges had today in the Miller versus Bonta case were questions that were already raised in the U.S. Supreme Court by the dissenting judges, and guess what? The Supreme Court didn't care. So these lower court inferior judges in the Ninth Circuit should be following the Supreme Court precedent, but they desperately don't want to because they know what it means, which is that we get our AR-15s in California the way we get it all over the rest of the United States. So let's roll the tape and see what the judges say and the rebuttal and response to it by the Second Amendment lawyer.
Afternoon, Your Honors. May it please the Court, Pete Patterson for the appellees. Under Heller and Bruin, this is a straightforward case. Those cases establish that law-abiding Americans have an absolute right to own firearms that are in common use for lawful purposes. And
isn't that just irretrievably circular? I mean, if there were an assault weapon ban still in a federal assault weapon ban, presumably the numbers of these weapons that were kept by individuals would be way less.
Two answers to that, Your Honor. The first answer is that the allegation of circularity was given in the dissenting opinion in Heller, and nevertheless, the Supreme Court said that the test is in common use. Second, it is not circular because with a representative government in this country, presumably, an item that a substantial portion of the population believes is effective for lawful purposes, a ban of that item is not going to be able to be maintained for long periods of time across broad swaths of the country. And that's what we see here. These firearms have not traditionally been illegal in this country, as the Supreme Court itself held.
The only other point I want to make about this video, and we will cover this and break it down more, there's a lot of teaching points in this oral argument. We can go over it later. But the one specific thing that's very interesting and what's going to happen in this case is pretty clear that the judges are trying to dodge doing their own job. Because what they're trying to say is because the Miller case deals with quote-unquote assault weapons, and the Duncan case, which is up in the Ninth Circuit Court of Appeals en banc, deals with the question of magazines, and they're very similar. It seems like what this panel is interested in doing is simply doing nothing until the en banc decision comes out by the Ninth Circuit, and then maybe they will act. Best evidence of how they're trying to get around this, I think, pops up where we're asking the state of California really to give them excuses as to why they can dodge doing their job now by sending this case back down for more information. But actually, California was not buying into that question from the judges. You'll see right here.
At the threshold stage, the plaintiffs have not met.
Actually, counsel, if I
Yes,
could jump in
of
and
course, Your
interrupt
Honor.
you for a moment before you get to that threshold merits question. In the state's view, is the record fully developed in this case? I appreciate and recognize the fact that the Seventh Circuit case of Bevis was in a different procedural posture because that was a preliminary injunction stage, but at one point in the opinion, the circuit said that there could be some development of the record that would aid in the court's view as to whether an AR-15 is closer to an M16 or whether it's closer on the other line. You've had multiple opportunities to brief and present evidence. The district court, in the state's view, have you put everything that you've got on the table there?
All right, folks, so there you have it. Got a little taste today of what happened in the Ninth Circuit. At the end of the day, we're clearly not going to win this panel. I think if they do anything on the merits, we will lose 2-1 with the two liberal judges desperately refusing to apply the law and respect the Second Amendment. That is obvious beyond all doubt. Judge Miller, the Trump appointee, seems much more amenable to listening to the arguments and getting it right. But the two liberals are absolutely hopeless in all respects. One of whom, of course, is a Biden judge. The other is a longstanding liberal, going all the way back, written anti-gun screeds in the past in her opinions. So basically, it's going to be a 2-1 decision. Or alternatively, they may just simply sit on this for while we wait for the en banc decision in Duncan. So sort of unfortunate news in many respects for California gun owners, but there's nothing we can do right now except let the process play out for the moment. So there you have it. All right, folks, hope you learned something here today. I'll keep you apprised as things develop. Don't forget to follow me on X at 4boxesdiner. Make sure you subscribe because a lot of people are getting knocked off the subscription list on YouTube. So make sure that doesn't happen to you. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.